the Gender Advocacy and Housing Initiative lead at the Colorado Poverty Law Project. I'm joined by Olivia Kohrs, who is a managing attorney at CPLP. We won't spend too much time introducing ourselves because we know that Kathy shared our bios, but we're again thrilled to join you to talk about the housing protections for victim survivors of gender-based violence. So the Colorado Poverty Law Project's mission is to prevent homelessness through legal representation, education, and advocacy. And we do that because we believe that no one should become homeless for a lack of access to housing justice. And so we represent tenants throughout Colorado in evictions, fair housing cases, things like that, mobile home park residents. We do community education like we're doing this morning, which we always love to do, and policy and community advocacy. We are excited to have a new initiative, the Gender Advocacy and Housing Initiative, which provides holistic advocacy for tenant victim survivors of domestic and sexual violence, dating violence, stalking, domestic abuse, and unlawful sexual behavior in Colorado. We have a once-a-month in-person legal clinic in Adams County, and we offer direct legal representation to tenant victim survivors, including on issues such as lease breaks, VAWA issues, the Violence Against Women Act, eviction defense, discrimination, retaliation, and things similar to those legal issues. We provide housing navigation support and direct client assistance support. And again, we really emphasize our community education and advocacy program. So again, we're so excited to be here. We're lawyers, but we're not your lawyers. So, we will offer this disclaimer right at the top that this is not intended to be legal advice. It is instead general legal information about Colorado housing law. This does not create an attorney-client relationship between the audience or CPLP. And if you have a legal claim or issue that you want to talk to an attorney about, please reach out to us or contact an attorney so we can understand more of the specifics of what you're experiencing to give a more specific and confidential answer. The information in this presentation is current as of today, November 12th, 2024. We all know laws are subject to change, and so anything after today we can't necessarily say is necessarily current, but certainly as of today, it is. So quick overview, we will start off by giving kind of a grounding and a background in housing and gender-based violence. We know that the language that we use is very important when we're describing these kinds of, this kind of abuse, these kinds of actions. And so we'll take some time to go through the terms that we use when we talk about various laws. We will go through the Federal Violence Against Women Act and kind of the basics of that law. We'll talk about some Colorado state-specific law, specifically surrounding lease breaks and the eviction process. We'll do a quick comparison between Colorado and VAWA, Colorado law and VAWA. I know we have some folks from the Address Confidentiality Program here, which is exciting because we will talk quickly about that program and how it can support victim survivors. And then we will share we have so many wonderful resources in Colorado for victim survivors. We'll share just a few of them. We know that as lawyers, we can talk a lot. We encourage you to raise your hand or put a question in the chat as they come to
Kristen,
you.
how are you? Good. Hey, do you have a minute real quick?
Oh.
Okay. I know you're not on call.
Ask folks to make sure that they're on mute. Yes, thank you. And so feel free to put questions in the chat or raise your hand, and we'll try to get to your questions as they happen, and I know we'll also have some time at the end for questions. So with that, I will hand it over to Olivia to get us started.
Thank you, Ariane. So I'm going to start out with just some basic information and then turn to the definitions. So to kind of get us all on the same page, some statistics. So 13% of unhoused Coloradans are fleeing domestic violence. 1 in 5 unhoused youth nationwide are survivors of human trafficking. And 19% of unhoused adults reported being physically or sexually assaulted while homeless. So I'm going to turn to some definitions. As Ariane mentioned, the language that we use is really important. And here we have this added layer that you'll see we reference specific terms that show up in the law and the definitions, and what falls into those different categories depending on the law are really important. So stick with me. This could get a little bit dense. I'm going to be doing a little bit of reading. I typically wouldn't read directly from slides, but here the exact language is really important. So I'm going to start there. Feel free, as Ariane said, to jump in with any questions. And then once we get through sort of this beefier definition section, things will open up to a little bit more of how everything applies and sort of what things look like in practice. But this section is going to be a little language dense. So I'm going to start out with some definitions under VAWA. So starting with domestic violence. So this includes the use or attempted use of physical abuse or sexual abuse, or a pattern of any other coercive behavior committed, enabled, or solicited to gain or maintain power and control over a victim, including verbal, psychological, economic, or technological abuse that may or may not constitute criminal behavior by a person who fits in one of these specific categories. So these categories are going to include a current or former spouse or intimate partner of a victim or person similarly situated, someone that's cohabitating or has cohabited. I rarely say cohabited, right? So we're gonna keep stumbling over that one. Has cohabited with the victim as a spouse or an intimate partner, shares a child in common, or commits an act against a youth or adult victim who is protected from those acts under another law in the jurisdiction. Dating violence. So under VAWA, dating violence is going to be defined as violence by a person who is or has been in a social relationship of a romantic or intimate nature with the victim. And determining whether this relationship exists is it's gonna be a little fact specific. You're gonna look at the duration, the type, and the frequency of interaction. Sexual assault is going to be defined as any non-consensual sexual act prescribed by federal, tribal, or state law, including when the victim lacks capacity to consent. And then stalking under VAWA is going to be defined as engaging in a course of conduct directed at a specific person that would cause a reasonable person to fear for that person's safety or the safety of others, or suffer substantial emotional distress. Continuing with definitions under VAWA are going to be economic abuse. So in the context of domestic violence, dating violence, and abuse in later life, this means behavior that is coercive, deceptive, or unreasonably controls or restrains a person's ability to acquire, use, maintain economic resources to which they are entitled. And that's going to include using coercion, fraud, or manipulation to, for example, restrict a person's access to their money, their assets, credit, or financial information. It's going to be unfairly using a person's personal economic resources, again, including money, assets, credit, for someone's own advantage. and it's going to include exerting undue influence over a person's financial and economic behavior or decisions. This could be forcing default on a joint or other financial obligation. It could be exploiting legal relationships like a power of attorney or a guardianship or conservatorship. It could be failing or neglecting to act in the best interest of the person to whom there is a fiduciary duty. So there's a couple different things that kind of fall into this category here. So that's going to be the definitions under VAWA. And as Arian mentioned, we're going to turn to the definitions under Colorado law. You're going to see some similarities. You're going to see some differences. And Arian's going to jump into kind of what those mean on the ground in a little bit. But for now, I'm going to talk through the Colorado law definitions. So in Colorado, domestic violence is going to be defined as an act or threatened act of violence upon a person with whom the actor is or has been involved in an intimate relationship. This also includes any other crime against a person or against property, including an animal, or any municipal ordinance violation. This one gets a little dense. Any municipal ordinance violation against the person or property, including an animal, when those things are used as a method of coercion, control, punishment, intimidation, revenge, directed against the person with whom the actor is or has been involved in an intimate relationship with. So what is an intimate relationship under Colorado law? That's going to be a relationship between spouses, former spouses, past or present unmarried couples, or persons who are both the parents of the same child, regardless of whether those persons have been married or have lived together at any time. Okay, and then domestic abuse under Colorado law. This is going to be any act, attempted act, or threatened act of violence, stalking, harassment, or coercion that's committed by any person against another person to whom the actor is currently or was formerly related, or with whom the actor is living or has lived in the same domicile as the home, or with whom the actor is involved or has been involved in an intimate relationship. Here, a sexual relationship might be an indicator, but it's not going to be a necessary condition for finding an intimate relationship. As a note, coercion here includes compelling a person by force, threat of force, or intimidation to engage in conduct from which the person has the right, the ability to decide they don't want to do or abstain from. And it also may include, domestic abuse may include an act, attempted act, or threatened act of violence against the minor children of either parties, an animal owned, possessed, leased, or kept by either parties or the minor child, and with which the threat act or attempted act is intended to, again, coerce, control, punish, intimidate, or exact revenge on either of the parties or the minor child of the party. Okay. Then stalking under Colorado law. So under Colorado law, a person commits stalking if directly or indirectly through another person, the person knowingly makes a credible threat to another person and in connection with the threat, repeatedly follows, approaches, contacts, or places under surveillance that person, a member of that person's immediate family, or someone with whom that person has or has had a continuing relationship. It also could be someone making a threat, a credible threat to another person, and in connection with that threat, repeatedly making any form of communication with that person, their immediate family, or someone with whom that person has had a continuing relationship. It also could be repeatedly following, approaching, contacting, placing under surveillance, or making any form of communication with another person, or a member of that person's immediate family, or someone that person has had a continuing relationship with, in a manner that would cause a reasonable person to suffer serious emotional distress and does cause that person, the member of their family or the person they have a relationship with, to suffer serious emotional distress. For the purposes of that particular section, a victim doesn't need to show that he or she received professional treatment or counseling to show that they suffered that abuse or that serious emotional distress. That's kind of getting into the weeds a little bit, but they include that as well. And then finally, under Colorado law, here is a list of some unlawful sexual behaviors. I'm not going to read through them all, but I'll give you all a moment to kind of glance through them and sort of keep them in mind as we move to diving into VAWA, diving into Colorado law, and sort of referencing back to these definitions. And with that, I will pause for any questions, and then if there are none, I will turn things back over to Ariane.
All right. Again, feel free to add questions in the chat as they come through, or if you have any as they come up. So, like Olivia said, we have differences in the kinds of behavior, the kinds of activities that are covered under VAWA and Colorado law. First, we're going to talk about federal law. The Violence Against Women Act, or VAWA, has the most comprehensive housing protections for victim survivors of gender-based violence, and is really kind of the heart of all of those laws. So to have a situation that falls under VAWA, you need kind of three key ingredients. One is there needs to be a covered property. Two, there needs to be a covered individual. And three, there needs to be what's referred to kind of collectively as a VAWA crime. And as Olivia told us, that is under VAWA domestic violence, which includes economic abuse, dating violence, sexual assault, and stalking. So those are the four behaviors that we talk about when we talk about VAWA. So the first is a covered property. What properties fall under the protections of VAWA? Generally, VAWA covers housing programs that are administered by the federal government, primarily the Department of Housing and Urban Development, or HUD, USDA, the Department of Agriculture, or the Department of the Treasury. Some of those properties include housing programs, sometimes referred to as Section 8 vouchers, which include housing choice vouchers and project-based vouchers, supportive housing for the elderly with disabilities, housing opportunities for persons with AIDS or HOPWA, homelessness programs under the McKinney-Vento Homelessness Assistance Act, or low-income housing tax credit or LIHTC properties. And a note that DV shelters are not considered a dwelling under VAWA because they're not intended to be kind of permanent long-term dwellings. And so even if those shelters do receive federal money, they're generally not considered a dwelling under VAWA, and so those are excluded from what is considered a covered property. Next, we'll talk about who is covered under VAWA. And VAWA protects any individual who is or has been a victim survivor of an actual or threatened VAWA crime and is living in or seeking admission to any of the covered housing programs. I think what's also important to note about VAWA that you'll see kind of throughout this next set of slides is that it's an actual or threatened or perceived VAWA crime. So there's generally not the requirement that a victim survivor or a tenant under VAWA prove that the crime occurred. It could be threatened or perceived as well. Other covered individuals under VAWA include the victim survivor's affiliated individual, which could be a spouse, parent, sibling, and child, an individual to whom the victim stands in loco parentis or is the legal guardian for another person, or an individual or tenant or other lawful occupant in the victim's household, which generally would cover, roommates or folks that the landlord knows. are coming with that tenant. And VAWA is not well named. It's the Violence Against Women Act, but it applies to victim survivors of all gender identities and all perceived gender identities. So it certainly extends beyond women or those who identify as women or femme. Okay, so we have a VAWA crime, we have a covered property, and we have a covered individual. What does VAWA sort of trigger? What protections does VAWA include? Generally, VAWA is going to prohibit a victim survivor of a VAWA crime from being denied admission to or assistance with their housing in a covered program, terminated from participation in a housing program, or evicted solely on the basis of experiencing domestic violence, sexual assault, dating violence, or stalking if the tenant or applicant otherwise qualifies for admission, assistance, participation, or continued occupancy. We'll get into that in a little bit more detail with regard to eviction in a moment. But generally, the tenant or applicant does need to otherwise qualify, right? So if the tenant doesn't or an applicant doesn't qualify for the federal housing program's admission guidelines, maybe they make too much money, for example, or they've they don't qualify for the program and they've experienced these crimes. If they don't qualify, that's a lawful reason for a housing provider to deny them housing. So experiencing a VAWA crime doesn't automatically qualify somebody for these housing programs. VAWA also prohibits discrimination on the basis of actual or perceived sexual orientation, gender identity, or marital status, as do many federal laws. But VAWA specifically calls that out in terms, in the context of gender-based violence. So covered housing providers cannot evict or terminate housing support for victim survivors because of actual or threatened VAWA crime, meaning, for example, violence or damage to a unit caused during the commission of a VAWA crime or perceived VAWA crime cannot be the basis of the eviction. There might be other reasons for eviction, but experiencing that crime, again, or a perceived crime, cannot be the basis of an eviction. Housing providers also can't interfere, right, with their tenants exercising or attempting to exercise their rights under VAWA. So, specifically, that means they can't coerce someone to not make a report, intimidate them by saying, if you make a report or if you participate in this investigation, you'll lose your housing. Similarly, threatening, interfering with, preventing somebody from making a report or an investigation, or retaliating against a tenant, which can look like, again, sort of shrinking services that are available to the tenant, not providing maintenance, charging fees, things like that. Generally, housing providers cannot impose any adverse actions against a tenant for invoking their rights under VAWA. Confidentiality is also an important protection under VAWA because VAWA specifically prohibits landlords from sharing certain information about the parties involved in a VAWA crime or the details of that VAWA crime throughout the sort of process of invoking the VAWA protections and the rest of the tenancy. We see this happen less often in Colorado, but again, VAWA is a federal law, so it takes into consideration, conditions across the country. Many jurisdictions nationally have what we call nuisance ordinances, where if you call the police X number of times, that's an automatic eviction, for example. So VAWA provides an affirmative right to report crime and emergencies from one's home. That can be a homeowner, a landlord, a tenant, a resident, an occupant, a guest, again, or that affiliated individual, a spouse, a child, a roommate. And the reporter can be the victim survivor themselves or anyone on behalf of the victim survivor. Again, like VAWA prevents retaliation against invoking VAWA rights. In response to a report of crime in one's home, a housing provider cannot impose actual fees or threaten to impose fees or criminal penalties, evictions, or refuse to rent or renew a lease. And authorities like the city or the state housing agencies cannot close the property, designate it as a nuisance, or give it a similarly negative designation. You set it up for condemnation or something like that, or refuse to issue a new occupancy permit based on the amount of crimes that are reported from that property. Okay, so evictions. Like we've said, can't be evicted solely because of the actual or threatened VAWA crime, which means it's also not considered good cause to evict under federal law and now under Colorado law. A landlord has to have good cause to evict a tenant, and the experience of an actual or threatened VAWA crime on its own cannot be the basis for an eviction. But if the victim survivor, both demonstrates a VAWA crime and commits a separate unrelated lease violation, they could still face eviction. So, for example, if there's a commission of a VAWA crime in the home that leads to some kind of lease violation, but then, potentially, noise violations or noise complaints from neighbors about the violence going on in the home. But then the victim survivor, who's the tenant, also, let's say they can't have a grill on their patio. Their landlord has told them not to have a grill on their patio, but they keep the grill on their patio. They can't be evicted because they've experienced the violence and caused sort of that noise disturbance to their neighbors, but they might still be eligible for eviction if they, don't follow their lease by keeping a grill outside on their patio. Now, we know that the nature of gender-based violence makes these, violations and these behaviors difficult to tease apart. So what does a separate unrelated lease violation mean? Again, these are highly fact-specific questions, and something, we're always happy to talk a tenant through because we understand that what a landlord thinks is separate and unrelated might not actually be separate or unrelated to the abuse. For example, non-payment of rent or economic abuse, like Olivia pointed out under VAWA and federal law. Separately, tenants might be able to be evicted if the housing provider can demonstrate that if they don't evict the tenant, there is an actual and imminent threat to neighbors, to the landlord, or to employees of the landlord. And evicting the tenant is the only way to remove that threat of actual and imminent violence. Generally, the housing provider needs to demonstrate that the abuser is a guest of the tenant or someone that the victim survivor has invited in order to make that connection, because we know sometimes there might be a protection order in place, for example, and the abuser violates that protection order to come menace the tenant. And generally, VAWA would prevent a tenant from being evicted because of that, even if there is actual or imminent threat. Again, we know that if the victim survivor invites their abuser over, it's not necessarily something that they have a lot of control over. And so this is another place that it's, I think, useful for folks to talk to a housing attorney.
That feedback you gave me really messed me up. I was like, It's
I'm going to remind folks to mute. Thank you. You know, we invite folks to talk to housing attorneys about sort of the allegations that their landlords are making, and you know, we can try to help advocate for those tenants when, you know, talking with their landlords about what the landlord thinks is going on versus what is actually going on for the victim survivor. So if a victim survivor is experiencing gender-based violence and you know, wants to avail themselves of VAWA's protections, generally the housing provider is likely to ask for documentation of that VAWA crime. They're not required to, but I have not seen a case where the housing provider did not ask for documentation. So if the housing provider needs or asks for this documentation, they have to make the request in writing. They have to give the victim survivor at least 14 days to provide that documentation. During that 14-day window, the housing provider can't take any adverse action, such as initiating an eviction proceeding or terminating the lease during that 14-day window. And you know, it has to be at least 14 days. The housing provider can extend that deadline at their discretion. The kinds of documentation that are available under VAWA, sort of four main buckets. The first, and I think most important, is a self-certification form that is approved by the appropriate federal agency. Generally, that's going to be a form that is produced by HUD, and that is a covered housing provider under VAWA is required to provide a written notice with accompanying forms, relevant forms, like this self-certification form at the beginning of a tenancy. So the tenant should have access to that, you know, with their lease. Again, they're easy to find and we're happy to provide them. But it needs to be that form rather than, you know, just a statement from a victim survivor. So in this form, the victim survivor states that they have experienced a VAWA crime, that the incident qualifies under VAWA. And there's a space for the victim survivor to include the name of their perpetrator if it's known and safe to produce. That is up to the victim survivor to determine. And if that name is not included in the self-certification form because the victim survivor says it's not safe or it's not known, that's it. The landlord can't push on that. The landlord can't say, no, I'm sorry, I actually require you to provide the name of your perpetrator, which is really important. The next option is a statement from a qualified third party.
A question.
Yes.
Can you repeat what crimes are covered under VAWA? I was
Yes.
taking notes and missed one of the slides.
Yes. VAWA crimes are domestic violence, which includes economic abuse, sexual assault, dating violence, and stalking. Thanks for asking that. I know it's difficult to keep track of all of the behaviors that we're talking about. So the next option for documentation is a statement from a qualified third party. This statement is signed by the victim survivor and the third party. Under VAWA, that third party can be a victim service provider, an attorney, a medical professional, or mental health professional from whom the victim survivor has sought assistance regarding the VAWA crime and its effects. I know we have some ACP folks on the call. This is sort of that version under VAWA, which again, you'll see is much more expansive than Colorado law. Third, the victim survivor can produce a police, court, or administrative record. This could be a restraining order, any kind of protection order, civil or criminal, temporary or permanent, a criminal complaint against the abuser or a conviction, or records from a custody hearing to sort of demonstrate the relationship and the kinds of abuse that can come with that. And then finally, sort of a catch-all miscellaneous category, which is other evidence that is accepted at the discretion of the housing provider. So maybe the victim survivor doesn't want to self-certify, or they don't have the means or the wherewithal at that moment, given the crisis that they're in, to locate a third party or report to law enforcement. But there might be other evidence that the victim survivor has of the abuse. Maybe they got a threatening text message from their abuser. Maybe the abuser has posted about them on social media. Things like that. Again, the housing provider is not required to accept these other kinds of evidence, but certainly is allowed to under VAWA. So quite a few documentation options under VAWA and federal law. Okay, so what does that get you, right? You've documented what happened to you, and you want some kind of remedy from your landlord based on experiencing this abuse. The first option that VAWA provides is what's called a lease bifurcation. This is when the tenant and the abuser are co-tenants on the lease, and it's a process by which an individual is removed from the lease following an actual or threatened VAWA crime. Now, this can be the victim asking to break their lease without penalty, and they can move out if that's what they prefer. Or the victim survivor can ask the housing provider, the landlord, to remove their abuser from the home and essentially evict the abuser. They call it lease bifurcation because generally when two parties are on a contract together, they're like this. They have the same contractual obligations, but in a lease bifurcation, you're essentially dissolving that contractual relationship and separating the two tenants from that contract. So the victim survivor can decide to stay or go, and that kind of determines what happens to the other party. In the case that a victim survivor chooses to remove the abuser from the lease, and the abuser is the one that qualified the household for federal housing assistance, the public housing authority or the housing provider must give the victim survivor a reasonable time frame to establish their own individual eligibility for the housing assistance. The point of this is to make sure that, as we see often, if the victim survivor is sort of dependent on the abuser for housing protection, that doesn't foreclose the opportunity for the victim survivor to get other kinds of support, right? To be able to let them qualify on their own. Generally, housing providers have to give a victim survivor 90 days to reestablish their eligibility. Now, if they can't reestablish their eligibility on their own, they might lose their housing protection because, again, victim survivors cannot lose their housing because they've experienced an act of gender-based violence, but they could lose it if they aren't, otherwise eligible for the housing support. All right. Another VAWA remedy is called an emergency transfer. This is where a victim survivor says, I'm not safe here, but I have a housing choice voucher and I want to take that housing choice voucher and move somewhere else. Or, I live in public housing and I shouldn't lose my public housing because I've experienced the VAWA crime. So, housing provider, I ask you to find me another unit that's safe for me to transfer into. Under VAWA, the standard for what a safe unit is totally at the discretion of a victim survivor. So if a victim survivor says, I am only safe in another building or another property that the housing provider controls, they are entitled to choose that option if they believe that's safer than, for example, changing floors within the building or something else. Really important to note about emergency transfers, it does depend on the availability of another unit or another housing dwelling that's under the housing provider's control. So if you live in, if you live in public housing, or if a public housing authority, for example, provides your housing and they don't have any other, properties available, then that's it's not a violation of VAWA for the housing provider to not find housing for that tenant if they just don't have anything. Also, because a private landlord can accept housing vouchers, if the private landlord, for example, only has one house, they only rent out one house, and the tenant victim survivor lives in that house, then that landlord is not required to go out and find an available unit for the victim survivor to transfer into. It has to be under the landlord's control. Finally, if a tenant believes that their rights under VAWA have been violated, they might be able to file a complaint with the Department of Housing and Urban Development. HUD itself may then investigate and issue a finding of housing discrimination, and either party can refer the case to the U.S. Department of Justice to initiate a civil lawsuit. So we know that's a lot. Please reach out to us if you have questions about VAWA or for support in pursuing VAWA remedies. And now I'm going to turn it over to Olivia to talk about Colorado law, unless there are questions about VAWA. Good time to pause. Okay, go ahead, Olivia.
Thanks, Ariane. So I'm going to talk about what might be available to someone under Colorado law, what that looks like, and then Ariane will talk about some of the similarities and differences between Colorado law and VAWA at the end. So, Colorado state law and lease breaks. Under CRS 38-12-402, a tenant can break their lease without penalty if they are a victim survivor of domestic violence, sexual assault, stalking, domestic abuse, unlawful sexual behavior, and certain documentation is required. As another flag here, these are going to be tied back to the Colorado definitions of domestic violence, sexual assault, stalking, domestic abuse, and unlawful sexual behavior, where in the last law, or in the last section, the VAWA definitions were what was guiding that law. So, what is the lease break process if someone does wish to break their lease? So a tenant's obligations under this provision of the law to terminate without any sort of early termination penalties, they've got to provide their landlord with notification of their intent to break the lease in writing. They've got to specify the date that their lease will be terminated. And they've got to provide some evidence of the abuse. Here, that could be a police report written within the last 60 days. It could be a valid protection order, or it could be a written statement from a medical professional or Address Confidentiality Program application assistant who has examined or consulted with the victim survivor. Here, as a little note, a statement from a medical professional doesn't apply for victims survivors of stalking. So there are going to be some moving parts and some exceptions. As Ariane mentioned before, these areas can get really complicated really quickly. So if anyone ever has any questions or wants to chat with an attorney about how the exceptions apply or where things kind of fall, please do always feel free to reach out. Okay. So what happens after someone sends the letter to their landlord, lets folks know, or let the landlord know that they're planning on terminating their lease, satisfies all those requirements on the last slide. So after the lease ends, the victim survivor must vacate the premises by the date that they gave the landlord in the written notice. And I think I might have seen a hand, but then it went away. So I'm going to pause to see if there's a question here.
Yes, we have one in the chat that says, would a written statement from an advocate help in this process as well?
Yes, so in this particular section, an address confidentiality application assistant letter could absolutely support in the lease break process. And at the end, or in a couple sections, we'll talk about a few more details on like what that letter might look like and what sort of information when we're supporting folks through that process, what we're looking for and things like that. That's a really great question. Awesome. So the tenant must vacate by the date that they let the landlord know that they're going to vacate. And then they might be responsible for 1 month's rent after they vacate the premises. But, and this is the huge but, a landlord is not automatically entitled to 1 month's rent. The landlord may be entitled to 1 month's rent only if the landlord can demonstrate that they've experienced damages as a direct result of the lease termination. And also, the landlord has certain duties. So the landlord has a duty to mitigate damages. So the landlord can't, for example, just sit on the apartment and not try to lease it out and then say, oh, I lost out on this rent, even though they didn't try to lease it out. This obviously gets a little bit fact specific, and it looks different for everyone, but the landlord does have a legal duty to try to offset any of those damages. If the landlord does demonstrate that they experienced damages as a direct result of this lease termination, the victim survivor has 90 days from the date of move out to pay that. Additionally, if they are responsible for 1 month's rent after move out, the security deposit doesn't need to be returned to the tenant until the month of rent owed is paid. So at this point, there can be some moving parts, there can be some sort of back and forth and some negotiation that happens and a sort of particular order that things might need to happen in. So again, if someone finds themselves in this particular situation, feel free to reach out to an attorney to kind of chat through some of those moving parts.
Before we move away from lease breaks, Olivia, I just want to highlight a couple of questions from the chat about advocate letters. So currently, as the law is written, that written statement, that sort of option 3C, if you want a letter from either a medical professional or an advocate, under current Colorado law, that advocate must be an ACP application assistant. Like we said, it's quite narrow under Colorado law, where it's quite expansive under VAWA. But I just want to highlight that a general community-based advocate, we love the work, we love the support, but for that letter to qualify as a lawful lease break, the advocate writing that letter has to be certified with the ACP. And thank you for that note. Back over to you, Olivia.
Awesome, thank you. And I see a comment from Olive in the chat about sharing training info. We do not have that in this slide, so I would assume that would be abundantly helpful. Olive, if you don't mind sharing that information out. All right, so what is prohibited under Colorado law? What can't landlords do? Landlords cannot evict a tenant solely because they are a victim of domestic abuse, domestic violence, unlawful sexual behavior, or stalking. They cannot impose a penalty on, retaliate against, ask tenants to waive their rights to, or otherwise prevent victim survivors from calling police or peace officers, emergency response, for situations involving domestic violence, domestic abuse, unlawful sexual behavior, or stalking. They cannot disclose victim survivor's new address or information about the lease break without the tenant's consent. Evictions is an area that we're going to dive in a little bit more, and then we're kind of compare evictions and lease breaks, because there's different documentation, there's different ways that folks might be able to take advantage of the protections in either side. So for eviction specifically, tenants who face an eviction while experiencing domestic violence or domestic abuse might be able to raise that as a defense to an eviction for certain types of evictions that they might be facing. So that could be if they're facing a substantial violation eviction, a material violation eviction, or a repeat violation eviction. Here, they must provide corroborating evidence in the form of either a police report or a valid civil or emergency protection order. And here, you're going to see we kind of shoot off of the last documentation requirements. And here, no statement from medical professionals or ACP application assistants can be used as corroborating evidence for eviction defenses. Under current Colorado law, tenants cannot raise this as a defense for an eviction for failure to pay rent. This is obviously sort of a huge hole in Colorado law, as I'm sure we all can imagine the various ways that this defense could be really, really valuable to someone facing a failure to pay or a non-payment eviction. But the current state of the law does not provide this defense for non-payment eviction. Again, to demonstrate domestic violence or abuse as an eviction defense, a tenant cannot submit a letter from an ACP application assistant. And if someone is using this defense, the domestic violence or abuse must have caused the alleged lease violation. So it couldn't be something that was entirely unrelated. But again, this is going to get really fact specific, and it could be really valuable to chat through with an attorney on, all of the ways that everything is sort of interconnected, and whether there might be a way to demonstrate to a judge, to the court, that the domestic violence or abuse did cause the alleged lease violation, whatever it is in that particular instance. As an additional note on evictions, under new Colorado law, a landlord must have what's called just cause to evict a tenant, but evictions for violations of leases may continue. So there is a new class of evictions for nuisances or disruption of the quiet enjoyment of someone's neighbors. But experiencing domestic violence is explicitly not considered a nuisance under this new law. As a note, the exception for domestic violence does not similarly exempt the experience of other forms of gender-based violence. So we also want to call out a couple Colorado laws here. First, HB 24-1431. This one provides limited housing assistance payments to victim survivors of domestic and sexual violence who are eligible for TANF or Colorado Works benefits. It provides short-term assistance limited to 4 months, and the appropriation is limited to $2 million annually. And then HB 23-1120, that law is going to provide for mandatory mediation before a landlord can file an eviction against a tenant who receives certain types of benefits, if the tenant notifies the landlord in writing if they satisfy some requirements. This law also provides for 30 days between judgment and sheriff move out rather than the 10 days. So if someone goes through the eviction court process, they reach the end and the judge unfortunately sides with landlord and says, yes, eviction is entered. There are certain things that need to take place, but generally speaking, from what's called a writ of restitution to the sheriff showing up and physically moving someone out, is going to be 10 days in a normal circumstance, general circumstance. But for individuals who receive certain types of benefits and notify their landlord, that can be extended to 30 days, which gives folks a valuable extra 20 days to try and get everything in order. Obviously, 30 days is still not a lot to sort of move someone's entire life, but it's a little bit better than the 10 days. And failure to comply on the landlord's part with the mandatory mediation or with the timeline, though a landlord won't often have much to do with the timeline, can be an affirmative defense to an eviction. So it offers sort of another tool in a victim survivor's toolbox for going after defending against an eviction. Awesome. So here we have just side by side some of the requirements and the applicability of Colorado law for evictions and defenses against eviction actions and lease breaks. So eviction. The laws cover victim survivors of domestic violence or domestic abuse. The documentation that can be provided includes police report or a valid civil or emergency protection order. And the defense is only available in substantial, repeat, or material violation eviction cases. On the other side, we've got our lease break. This law covers victim survivors of domestic violence, domestic abuse, unlawful sexual behavior, and stalking. The documentation, again, is a little more broad as well. So it can include a police report within the last 60 days, any valid protection order, or a letter from a medical professional or ACP application assistant. And under this law, it allows for the tenant to sort of terminate their responsibility under the lease. And with that, I am going to pause again for questions and then turn things over to Ariane to chat through the similarities and differences between VAWA and Colorado law.
If you have any questions and want to come off mute or put them in the chat, this is a good time to do that.
We will also have time at the end, which I promise is coming, if folks want to save their questions too. Or if you don't have any, that's also okay. Okay. So I know I gave a lot of information about VAWA. Olivia gave a lot of information about Colorado state law. And there are some similarities and there are some really important differences. So before we kind of move on, we will just take a brief minute to kind of collect where we are and kind of run through those similarities and differences. So first, the similarities, right? Under both federal and state law, tenants who have experienced gender-based violence, which includes, domestic violence, sexual assault, stalking, or dating violence, might be eligible to change their housing arrangement. That might look a little bit different depending on what the situation is, but without penalty, right? So you can break your lease without penalty, and under VAWA, you can't be charged, additional money if you want to bifurcate your lease or if you want that emergency transfer, things like that. Generally, under both Colorado and federal law, these instances of abuse can't be the basis for an eviction or termination of housing support under most evictions. Generally, tenants who receive or who seek relief under each law have to provide some kind of documentation of the abuse to their landlord. And importantly, both laws require landlords or housing providers to keep at least some information about the abuse and about the people involved in the abuse confidential. But we have very important differences as well. So under only VAWA, there's the potential to remove an abuser from a lease via lease bifurcation, and the potential for the abuser themselves to lose their housing support. Only under VAWA is an emergency transfer a possibility. That option is not available in just under Colorado state law. VAWA recognizes the nuances of domestic violence and coercive control a little bit more by including economic abuse as a covered behavior, which is most likely to kind of present itself as the availability of raising this kind of defense in a non-payment eviction. And again, only VAWA has that positive requirement of the housing provider to notify tenants of their rights and provide those forms that we talked about, like the self-certification form, emergency transfer request form, at the beginning of their tenancy. No such obligation exists under Colorado law. Under Colorado law only, the landlord might be able to recover up to 1 month's rent from the survivor following the termination of their tenancy. But like Olivia said, only if the landlord can demonstrate their damages. That requirement or that possibility is not available to the landlord under VAWA. And again, under Colorado state law, there is not a defense available for non-payment evictions. And one other just quick difference to note is VAWA comes with its set of crimes, and those crimes are applicable throughout all of the housing protections. Domestic violence, dating violence, sexual assault, and stalking. Those definitions don't change depending on what kind of housing protection we're talking about. But again, under Colorado law currently, in evictions, those protections, those potential defenses are only available if the tenant has experienced domestic violence or domestic abuse. So Colorado law does kind of single out behaviors in a way that federal law does not. Okay, so our last segment, again, we know we have Olive here, who is the true expert in the Address Confidentiality Program. So we'll go through these slides pretty quickly, but we do like to sort of ground folks in the basics of that program in case folks aren't familiar. And then, like Olivia said, we do have some tips for effective, lease break letters. And so I will let Olivia sort of give an overview of this program.
Awesome, thanks, Ariane. So, just a very 30,000-foot view of what this program is. It provides legal substitute address and mail forwarding services for tenants who do not wish to share their actual address for safety reasons. Participation is valid for renewable 4-year terms. There's not a limit on how many times someone could renew, and participants can withdraw at any time. So there's going to be certain information that's kept confidential under this program and certain information that can be shared out. I'm not going to go through each line of this, but you'll see it in the materials and the reporting if you want to look into it more. But where we see this intersect with our work is when someone is eligible to participate in the program, and then on the next slide, sort of the letters and what information we see as helpful. Ariane, I'm going to ask that you go back to the last slide just briefly. Sorry, I won't spend a lot of time here. So to be eligible for the ACP, the applicant must be a survivor of sexual assault, domestic violence, stalking, or harassment who fears for their safety. Co-applicants can also be included. There's an evidence requirement. The applicant must have relocated, and they must reside in Colorado. For specifics, again, we are not the experts on this. We encourage folks to reach out to application assistance reach out to the ACP and folks that have been trained in this area to see if they can apply, what's required of them, and to help the survivor prepare and submit an application to participate. So, lease break letters. This is the area that we see the program and our work overlap the most. So, within these lease break letters, there is certain information that we see included that can sort of correlate to an easier time explaining to the landlord what the law is and what's going on, or just sort of a more comprehensive explanation to the landlord. So we see the letters including statements of the ACP application assistance status and their number, a confirmation of the opinion that the tenant has experienced gender-based violence and fears imminent danger due to gender-based violence. We see a confirmation of a victim survivor's intent to move and terminate the lease. And we see, to the extent that, you know, both parties are comfortable in working together on this, and obviously we know that there's a lot of layers to these situations, being as specific as possible can sort of help eliminate some of the back and forth or the confusion on the landlord part, or kind of streamline that process a little bit. Again, though, these are general guidelines, not legal advice. So if you do have questions about how we see these letters in practice, which ones we see more successful or with less back and forth perhaps, please do feel free to reach out to us. We're always happy to chat about that. And that is it for the ACP. And I will turn things over to Ariane for some resources.
All right, thanks, Olivia. So many of you on the call, and who are members of CCASA itself, are such excellent resources. We hope you'll forgive that we only had space for certain folks on one slide. There are so many others. These are a couple of resources that we refer folks to very often. Again, depending on where they are. Colorado Poverty Law Project is statewide, but we have some sort of concentrations in Adams, Arapahoe, Denver, Larimer counties, and so we want to include some resources just generally from each area, but know that we have so many more folks in Colorado who can support victim survivors of gender-based violence, and we appreciate everybody's work there. And that is all we have. I told you there would be a time that we would stop talking. And so if you have any questions, feel free to contact us. My email is here. If you have questions about or are working with a victim survivor and they have questions about their housing rights, maybe they're experiencing harassment, eviction, things like that, please feel free to reach out. My email address is right there. And then this link, copovertylawproject.org/get-eviction-housing-help, will take you to our intake form. But you can also fill it out if you need housing help outside of an eviction. So I know we have a few minutes left, and we're happy to answer any questions that folks had or have throughout and after the presentation.
Thank you so much, Ariane and Olivia. And please, anyone, take yourselves off mute or put it in the chat. And again, you will receive copies of the presentation with all the great resources. And I'm going to put a copy of the evaluation in the chat, but you'll also get a copy of the evaluation in my email to you. But please feel free to ask any questions right now. We have some little bit of time left. A lot of thank yous coming in. The recorded information will be on our YouTube channel, which is on the CICASA homepage, and it will be available later this week. Again, lots of thank